Tired. Everybody done tried, so we can get him enough, at least for about a year, so he can get stabilized. And they work with him and try to get him where he can know that he has to get a part-time job because he first get enough money to take care of himself. He don't have to be doing all, and we got to get these people like Darren all them. No, they got to get out the way. Then he can come and stay around me, or I might consider moving on. I really want to move to
Ma'am, can you
Jacksonville.
please mute yourself? Can you please
Oh, I'm
mute
sorry.
yourself,
I didn't know
ma'am?
you could hear me.
Yes,
Okay.
ma'am.
You good over here?
Where I do that at? Okay.
Look to the bottom of your device. There you go.
Hey,
They just won't let me in.
it won't? Oh,
That's Salmon is up to you. They came over. I don't know what's going on down there.
hmm. Let Melissa know.
Yeah, I'll close it out and maybe get on my phone. Cause I came up here for.
Can you hear me now? Ma'am, could you hear me?
We can hear you. We can hear you.
All right, thank you. Hmm.
You can mute.
You want me to mute?
Yes.
All right, Judge, are we ready?
Yes, hold on. I'm trying to get my camera together. I'm on my phone. I can't get online. I can't print a calendar. Let's see. There comes a calendar. Everything is coming in slow from down there. I can't see anything. Let's see. All right, now I see it. Okay. All right, I can't see anybody else, so I can just see
We can see you.
which courtroom it is. You can see me? Okay. I'll just get started. I was trying to get to gallery, but I can't find it. All right, good afternoon, ladies and gentlemen. We're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will be the defendant's initial appearance before a state court judge. So we're going to address several matters, including bond, possible arraignment, or a possible plea offer if one has been made by the state at this juncture. What is the
The
SAP?
reset date, Your Honor, is August the 27th.
All right, 8/27. And hold on one second. I want to begin by advising everyone that this whole entire proceeding is being live streamed as well as recorded, and that's live streamed on YouTube. Want to also remind the defendants if you have certain constitutional rights. The first being that you have a right to remain silent. Remember that anything that you state about the facts, the circumstances, and the occurrences of the case can and will be held against you. The state is here and they're listening. So govern yourselves accordingly. All right, deputies, who do we have first?
All right, we're going to do the add-on on position 1.
All right, that is Joshua Lavetta, 24 CR 005716J, charged at 1 count of battery. Pre-trial.
406 suspended license.
406, you mean, is that April of 06? That's what you say?
2004, 2006 suspended license.
Oh, I got you. Okay. Thank you.
Okay.
Your Honor, this case took place on August 13th, so that would be yesterday at 205 at 12th Street Northeast. The victim in this case is Shawanda Edwards. She's the girlfriend of the defendant. Police responded to the location for a physical assault. The victim reported that she was in the shower, and when she got out, she walked into her bedroom and was confronted by the defendant about things that he saw on her Apple Watch that he went through while she was in the shower. He got aggressive, irate. He began punching her in the chest, pushing her around the room. The officer noticed that she had a bruise on her chest and neck area that was also seen by the officer. The victim reported that she does not live at the location, but she is planning to move in there soon if they stay together after this incident. The defendant also had injuries. Your Honor, both of these defendants were, both the victim and the defendant were arrested in this case. However, the state is only pursuing charges against this defendant. Both the defendant and the victim left the location, appeared to be having a conversation. Both of them had told the officers they didn't want to press charges, and they arrested both of them anyway. The state's requesting a signature bond through pretrial services. We haven't been in touch with Miss Edwards because I believe she's probably still in the jail at this point. So in light of that, we'd be asking for no further contact. We'd ask the defendant to take anger awareness courses and no weapons, drugs, or alcohol while out on bond. And if Your Honor could sound for Miss Edwards, I don't know if she's out of jail or not yet, but in abundance of caution, thank you.
All right, Miss Edwards, are you on the Zoom, Miss Edwards?
No, Judge, she's here at the main jail. She's not on Zoom.
Okay. All right, who's the PD? Who's representing the defendant?
PD McLean. Let me text him it.
Wait, this is an add-on name too?
Yes, Joshua Lavretta.
I've not interviewed that person, but I'd be glad to in a breakout.
Okay, we're not gonna do this today, you all. Please tell me right now, who have you not interviewed? What's going on? Because I hate when we start our calendar and then you tell me at that point you haven't interviewed someone. Tell us that initially, get to the jail so that they can happen, because that holds us up terribly when we have to wait for you all to interview. Then we can't do your cases while you're interviewing, and it just holds up everything.
No, I understood you. My clients today are Moss, Takula, and Shabazz. And I'll be glad to interview the add-on.
Is that the only one? Is that the only one you have to interview, Mr. McLean?
That's correct.
Okay.
Your Honor, do we have any breakouts today from anybody? So that we'll get those out the way too.
I don't have any.
Okay.
Wasn't Moss supposed to be a breakout from yesterday and he was reset?
Moss and Takula, I'm waiving their physical presence. I talked to them today on the phone. I went and talked to them more in person.
Okay. So they're waivers. Okay.
Your Honor, actually,
they're not. I'm not waiving their hearing though. Just their.
No, I know waivers meaning appearance. Yes.
Exactly.
What were you saying, PD Kim?
I apologize. Yes, I apologize, Your Honor. I just realized Joshua Laverta. I interviewed him actually, Your Honor. I apologize. I have to ask for a breakout room for him. So that will be the one case that I need to have a breakout.
All right. So it's not Mr. McLean. This is PD
It
Kim.
was not. I apologize.
Okay. Put us in a breakout quickly. We can get it over with since that's the only one we need a breakout for.
Yes.
Who all is going in the breakout room, Judge, and you want to do it now, or do you want to do it at the end of the calendar?
Do it now, get it over with. I don't know. PD Kim?
Me.
Me.
Okay.
Miss Kim,
Miss Allen can go too.
Miss Kim, is this an inmate's issue or?
For security purpose, we want to get him done first, so we can get him out of the courtroom for security purpose.
Okay.
Yeah,
Okay.
we're doing it now. Mhm.
Right.
All right, can you all hear me now? Ms. Bridgewater?
We can hear you.
Okay. Ms. Bridgewater, you there?
Yes, we hear you, Judge. She's there.
Okay, thank you. I cannot figure out how to get back to gallery for some reason. Okay, hold on a second. Okay, all right, for position, 1 on the add-on, I'm going to grant a $3,000 signature bond through pretrial, level 1. No further contact with the victim, Ms. Edwards. I'm going to order the 2-day anger awareness course. No drugs, alcohol, weapons, or guns while on bond. Is that it, counsel? Anything else I missed? Hello?
Nothing further from the case, Your
Nothing
Honor.
from the state judge. Thank you.
Because I can't see anybody. I'm like, are you all there?
Yes,
Sorry.
we are here.
Okay.
You said 3,000 pretrial, right?
Yes.
Okay. So who's next?
Number 1, Giselle.
24 CR 0057066Y. Kiara Dale charged with 2 counts of giving false name law enforcement.
Nah, total of 9. 2024, 2023 probations. 2023 given false name conviction. Can you hear me?
Yes.
Yes.
What happened to my screen? All right. 2020 serious injury by vehicle, DUI conviction. 2012 FTA, 2012 shoplifting conviction. Jail was the recommendation.
All right.
Your Honor, this incident took place yesterday. South Fulton Narcotics and Gang Unit and South Metro SWAT were executing a search warrant at the guest house located at 4980 Welcome All Road in College Park. All of the occupants of the building were detained during the search. The defendant was one of those occupants. The officers found several items of contraband within the house, drugs, money, scales, etc. They were attributed to other individuals in the house. While everyone was detained, the defendant gave the officer the false name of Alexis Dell and the false date of birth of January 23rd, 1996. She was properly identified via fingerprint scanner, and she did have 2 warrants for her arrest for probation violation and a failure to appear. Judge, given that she has an open failure to appear and has an open probation violation and has a previous conviction for the same offense, the state would be asking for a $500 good bond on each count. So it's a $1,000 good bond total. No weapons, drugs, or alcohol out on bond. Thank you.
All right. PD.
Yes, Your Honor, that's mine, Keith Cook. My client is 32 years old, has lived in the area her entire life. We understand the state's position. I believe she has, I think I saw a hold, but I'm not sure if that was correct. We would be asking for a signature bond at whatever level the court deems appropriate, so she could go ahead and settle her other issues here.
And Your Honor, she does have 2 holds. Looks like she's got one for Union City and one for Clayton County.
Yes.
Okay. All right, I will order a $2,000 signature bond through the jail, 1,000 on each, so that she can be released to either of her holds. No drugs, alcohol, weapons, or guns while on bond. And I guess that's it.
Thank you, Your Honor.
Mm-hmm.
Listen to.
Okay. 24 CR 005707B. Joshua Freeman, charged with 1 count of simple battery, family violence.
17/2024 trespass. Appears to have an open case out of Louisville for reckless driving, 2 counts. Got a Carroll County case for trespass, possession of a firearm, possession of marijuana with ITD, I guess with intent. I don't know why they put it like that. Discharging a firearm near a street or highway. It's 22 CP 207229. 2022 probations, 2018 and 19 probation, 2017 probation, 2017 failure to appear, and 2016 burglary conviction. State.
Your Honor, this incident took place yesterday, August 13th. Officers were dispatched to a fight call in the areas of Hollis Cobb Drive and Peachtree Dunwoody Road. The victim in this case is the defendant's wife. Her name is Whitney Freeman. She also called the police. She told police that she's been married to her new husband for 4 months. They were fighting, and she called the police because she wanted to be left alone. This altercation happened on a roadway. Criminal intelligence units were actually watching the fight on traffic camera and alerted officers in the area after they saw the defendant strike Miss Freeman a couple times in the head and neck area. And then they also saw him throw a bag into the tree line. The officers arrived on scene and arrested the male. They did find what he threw in the woods. It was marijuana. The state's not pursuing the charges for the marijuana. Our office has been in touch with Ms. Freeman. She states that what's in the warrant is accurate. She said they're married. She does not fear for her life. This incident hasn't happened before. She's okay with no violent contact and okay with the defendant returning to the residence. She admits the dispute got out of hand, and I believe she's on the Zoom. Your Honor, because of his several open cases and several recent arrest cases, although they are nonviolent cases, it does show that he has a propensity not to follow the court's orders, which his bond conditions would say not to violate any other laws of the state. The state's requesting a $1,500 good bond in this case. No further violent contact with Ms. Freeman. Take and complete an anger management course. No weapons, drugs, or alcohol while out on bond. And if the court can sound for Ms. Freeman.
All right, Ms. Freeman. Miss Freeman. I don't think she's on. All right, PDs.
Yes, that's my case, Your Honor. We would
Okay.
have no objection to the conditions of the bond. We would be seeking a signature bond at whatever level the court deems appropriate. There's just the one charge. So I have not been able to get to talk to Ms. Freeman, but apparently she does not fear his return. So we would be asking for no violent contact. And we would object to a stay away, although the address I have is not, well, the location of the incident is not where they lived. So we would be seeking a signature bond to whatever level the court deems appropriate.
I'm going to order $1,000 good bond. With that $1,000 good bond, and the state has spoken to her, so you all are reckoning no further violent contact?
Yes, Your Honor.
Okay. No further violent contact. No drugs, alcohol, weapons, or guns while on bond. And I guess that would be it.
What was the bond?
1,000 good. Surety bond, good bond.
ACDC, you can go ahead.
Thank you. Good afternoon, Judge. This is going to be position number 7, Ms. Shabazz.
Okay.
That'll be me, Mr. McLean, Your Honor.
Okay. This is 24 CR 005710A. Ms. Shabazz charged with 1 count of battery family violence, 2nd count of simple battery. Pre-trial.
I got first.
Okay. State.
Your Honor, that's my case. This is Anna Allen for the state. My information is that this is the first arrest as well. I also would note for the court that when I ran the information of these parties in the system, there was a call to the police in July of this year on the 23rd or 24th, alleging that the victim in this case shoved his mother-in-law. And he was not arrested because he had left the scene. So there is clearly something going on in this household. This is an incident that occurred on the 13th, so yesterday, around midnight at 1700 Stanton Road. The police were called. It's alleged that Mrs. Shabazz, who's in front of you, struck her husband, Mr. Lorenzo Smith, with a closed fist. He was seen to have a scratch about 6 inches, it's described as, on his arm. These young people, I believe, were married on August the 7th. And they share a very young infant, 4 or 5 months old. The victim on scene, Mr. Smith, told police he was in fear for his life and said that his wife and his mother-in-law, Ms. Moore, attacked him. He said that he came home at 9 p.m. and showered, and his wife brought him a plate of food, but he threw it away because it wasn't warm enough. Maybe these guys don't have a microwave. He became upset with her. She became upset with him. Mr. Smith reports that his wife, Mrs. Shabazz, punched him in the head and scratched him. It looks like maybe a marriage license was ripped up or shown and used during this argument and questioning each other about whether we're being respectful or not. Mrs. Shabazz denied that there was a physical assault and said that she had not caused the injury that was seen on his arm, but she was detained. Mother-in-law, Mrs. Cassandra Moore, was present. She said she didn't witness the altercation, but she heard a verbal in the bedroom. And she heard a bang. She reported that the 5-month-old was in the room with them. And it was her opinion that this couple's not doing well. We've been in touch with Mr. Smith. He reported that the 4-month-old is with his sister or her sister, maybe? No, his sister. And he would like no contact, and he would like these folks evicted from his home. Your Honor, we would request no contact. That seems appropriate, maybe in this situation. We would not request no contact with Ms. Shabazz and her infant, however. And it seems like maybe they're going to be moving out, but I would request a one-time law enforcement escort to the location so Mrs. Shabazz can get her things and her mother-in-law can get her things before they leave. We'd ask for a $2,000 surety bond, Your Honor. No drugs, alcohol, or weapons.
Okay. All right, PDs.
Your Honor, it was unfortunate that the mother-in-law moved from her location here in Atlanta into the household to help take care of the grandchildren. And now this occurs, Your Honor, taking into account the July matter, which apparently is just a 911 transcript at this point. I don't know if there's going to be a warrant. We would certainly agree with the state about no further contact, at least no further violent contact. And the state's asking for no contact at all. If the court needs to order third-party transfer of the infant for any visitation, that would be up to the court. I would ask for a signature bond, given this is their first arrest. Your Honor, my client is 25 years old. Let me turn to the biography here. 25 years old, from Iowa originally, but been in the Atlanta metro area several years. She's been a homemaker. She has had some college education, a little bit, and has some work history in a fast food restaurant. And as far as moving out of the place, this apartment on Stanton Road, I had a three-way conference call between one of my social workers and Ms. Shabazz while interviewing her, and we've given her a couple of resources for shelters. This is going to be a hassle, but it looks like may be worth the effort. We would ask to give a signature bond and rule appropriately in the court's opinion on violent versus no contact whatsoever.
All right. I will grant a $2,500 signature bond through pretrial.
And Your Honor, Mr. Smith is on the Zoom if you'd sound for him.
Oh, Mr. Smith? Do you wish to address the court today?
Yes, I will. I would like to.
Okay, raise your right hand for me so I can swear you in. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
And you're not driving, correct?
No.
Okay. All right, you can put your hand down. Are you in fear of Ms. Shabazz?
No.
Do you want to have any further contact with Ms. Shabazz?
Yes.
Okay. And you all have a small baby together, I believe?
Yes, Your Honor.
Okay. All right, I don't have any other questions. Anyone else?
No, Your Honor.
Okay.
I have a quick question. Mr. Smith,
Yes.
did you speak to an advocate in the solicitor's office this morning and tell them that you don't want any contact and you want your wife and her mother-in-law to leave the house and that the baby is now with your sister?
I do want contact with her,
Wait, that's
but I
not
do
what I
not want.
asked you. That's not what I asked you. Did you speak to our office this morning and tell them the opposite of that? That's my question.
Did I? No, I did not say the opposite of that.
You
I
spoke
said,
with
I
an
said,
advocate this morning and you
yes,
said you
I
didn't
did,
want
and I
contact
said,
and you
I,
didn't want them to return to the house and that the
I said,
baby was with your sister, right?
no, I said I didn't want them to return to the house, and I only want contact with her. That's what I said. Thank you very much.
Your Honor, again, I think there's obviously an issue going on here. Just the facts of this incident seem very strange to me, and the expectation of certain behaviors. The state is under the belief and opinion that it's in the best interest of both the mother-in-law and the victim in this case that there be separation. Thank you. And Miss Asua Johnson, you can't be on Zoom laying in your bed with a bonnet on. Please turn off your camera. I really do wish you had the ability to see people, Judge Mincy. Thank you.
Oh, thank you for helping. You normally I would. Miss Grace, can you, or who's my, or Miss?
It's already done, Judge.
Okay, or Miss Bridgewater, to see anybody else that way today? I don't, you're in court, so you wouldn't wear a court in person with a bonnet, so we don't do it on Zoom or hats or any other coverings. Thank you, everyone. All right, with the Shabazz case, I'm going to order the $2,500 signature bond through pretrial. No drugs, unprescribed drugs, alcohol, or weapons while on bond. No
Your
further.
Honor, there are two charges. You'll break that down, please.
2,000 on, well, no, let's see, 1,500 on the battery. And then what does that leave me with? 1,000 on the
Yes.
simple battery? Yeah.
Mhm.
And I'm going to, I don't know, I'm having some second thoughts about what's going on in the home, or if there's just a lot of chaos. And hopefully these people will get counseling or give some space and time to each other. I guess no further violent contact with the victim, which is the victim Mr. Smith? Or is it Miss
Yes, Your
Moore?
Honor.
Okay. But Miss Moore is the mother-in-law is at the home?
Right, and it sounds like he is demanding that she be removed from the house. He doesn't want contact with her. She's not a defendant in this case. That's not really how we can move
Yeah.
forward. That's not part of our case.
Right. That can't do
Can
anything
I
about
say
that.
something?
Not particularly, but what is it? Is it dealing with Miss?
So with the incident that happened on the 13th, when I called the 911, it was for the removal of the mother. It just so happened that the cop seen that we had got into an altercation, that she had got into an altercation with me, and that's why that happened how it happened.
Okay, you can sort out the facts as you go. I'm here just to determine bond and issues of whether
Okay.
persons will return to court, and to make sure that people are safe, whoever they are, who are residing in this home. So I expect that if Ms. Shabazz goes back there, that there won't be any more incidents with your mother-in-law, and that these issues will be cooling down. It's only been 24 hours or less since this happened. So I don't know if I'm going to allow Ms. Shabazz to go back there and no further violent contact. Can you all do that?
Your Honor,
And
what level will this be?
level 1.
Thank you.
And
And like I
since
said,
go
she
ahead.
does information from our social worker on a couple of places to go for shelter.
Right. Well, I did not order a stay away. I just said no further violent contact. So, but
Right.
if she needs help with that, hopefully you all can provide that as well. I don't know, again about a police escort to retrieve her items. I don't know that I need to order it, or someone request it without an order, will they do it? But if there still needs to be some cooling down going on, then I'll just order that one-time police escort just in case she needs it to get the assistance.
Your Honor, I think just based on the testimony of the victim during this Zoom, it looks like there should be some concern for the mother-in-law in this case. He's calling the police as if he can just have people who live in his home evicted in that way. And he's requesting, after telling us he wants no contact at all, he now wants contact. He just wants us to evict his mother-in-law, and that's not how it works. So it doesn't sound like Mr. Smith understands that he can't evict his mother-in-law and his wife from the home. We would want to make sure Mrs. Shabazz and her mother have the ability to go get their things, and we would request there be an escort from police because this seems like a volatile situation.
Okay. That's why I say I will order that, the one-time police escort, and we'll say for, is it I'm sorry, for the defendant and the mother-in-law?
The defendant is Ms. Shabazz, mother-in-law is Mrs. Moore.
Ms. Moore.
Yes. And obviously, once defense counsel talks to his client and the mother-in-law, if there are things we need to get together and address before the court or some kind of modification, we'll do that.
Right,
The focus here is about safety, and there is an infant involved.
right. All right. No drugs, alcohol, weapons, or guns while on bond. And I believe that's all I can order, all I will order at this point.
I have one last question.
Okay.
So with the signature bond, and you said it's 2,500, so I can go up there and pay it today.
The signature bond, she'll be signing herself out. But that's the amount if she violates any of those
Okay.
conditions and then has to come back to jail, it'll start 2,500 and usually doubles.
Okay, thank you.
All right, you're welcome.
Next judge is number 8, Taylor.
All right, this is 24 CR 005711F, Kendra Taylor, charged with 1 count of battery family violence. Pre-trial.
Third arrest, 2020 suspended license, 2019 shoplifting.
And that's my
Okay.
case, Your Honor. This is an
Okay.
incident between 2 biological sisters. This is a delayed arrest. This incident was in March of 2024. At about 3 p.m. in the afternoon, a call for service was received by the police about a dispute. The caller was the victim. Her name is Kayla Prothro, Prothro, excuse me. She called 911 and reported that she'd been assaulted by her sister, Mrs. Taylor. When police arrived, the victim explained that her sister had arrived at the residence with a few other people agitated, wanting to assault her. She was told by police that she needed to evict her sister, that she couldn't just kick her out because she lived there, and that she needed to get a TPO. The victim had called the police previously the day before as well, and reported that she had injuries from the incident. Police asked her to uncover the makeup that she was wearing, and they were then able to see a visible bruise, swelling welt on her forehead. She reported that her sister had thrown a folding chair and hit her in the head. The victim was told a police report would be written. Thankfully, a DV investigator, Muzon Hall, reviewed the body cam and the police report and took out a warrant for Mrs. Taylor for assaulting her sister, who lives in the same house, at least at that time, by hitting her in the head with a folding chair. We spoke to Mrs. Prothro. She may be on the Zoom, although she is working. She confirmed the information in the warrant and reported that she'd been struck in the head with a folding chair, that her sister no longer lives there, and they're not speaking. She wants no contact, and for the defendant to be ordered not to return to 3748 Hampshire Walk. The victim reported that the defendant is her younger sister. She's 24. The victim is 32. And she was trying to help her sister, but the criminal history and her behavior makes it a problem. So we're asking for a $2,000 surety bond, Your Honor. No contact with Mrs. Kayla Prothro, Prothro. Stay away from the location at Hampshire Walk, and no drugs, alcohol, or weapons while on bond. Thank you.
What?
Yes, my client, Miss Taylor, we have no objection to stay away and no further contact. They don't live together anymore. They have not had any contact. Your Honor, she is 24 years old. She had a baby about 6 months ago, so she has to return to take care of her baby and another child. She has 2 children, an 89 years old grandma that she has to take care of. She resides with the baby father right now. So we would like to request for signature on bond through pretrial, Your Honor. This is her first violence-related crime. I mean, other one was shoplifting, non-violent cases, a driver's license. So signature on bond through pretrial might be more appropriate. She does have a high school diploma, and yeah, that's about it. No further contact is okay with my client.
And Your Honor, Mrs. Prothro is on the Zoom, if you would sound for her.
All right, Ms. Prothro, or Prothro, not sure how to pronounce it. Do you want to address the court? If you do, yes or no, and I'll swear you in. All right, we'll move forward. All right, I'm ready to rule. And I can't see, is she not wanting to speak, correct?
Yes, I don't believe she's responded. Thank you.
Okay. All right, I'm going to order $2,500 signature bond through pretrial. I'm going to order 2-day anger awareness course. I'm going to order no further contact with the victim. No drugs, alcohol, weapons, or guns while on bond.
Level 1.
Level 1, I'm sorry, yeah.
Your Honor, would you please include that she needs to stay away from the location? We just heard testimony that she no longer lives there.
Right, and to stay away from the incident location at that Hampshire Way.
Yes, Your Honor.
Okay. That'll be it. Who's next?
Number 4, Johnson.
You said 4, I'm sorry.
I did.
Oh, okay. All right, 24 CR 0057008Y, Brian Johnson, charged with 2 counts of criminal trespass and damage to property, pretrial. Pretrial,
Can you hear me?
now I can.
Yeah, I don't know what's going on with the Zoom. 21 total.
Yes.
2024 trespass, giving false name. Got an open CWAC charge, well, related charge anyway. Possession of a firearm by convicted felon, giving false name. It's 24 PI 001829. Open hit and run, aggressive driving, speeding, reckless driving, suspended council registration, obstruction. This bunch of driving charges. Got Twiggs County, forgery in the 4th degree, 15 counts of that. Forgery in the 3rd degree, 4 counts. Financial transaction card theft, 13 counts. Simple assault robbery, suspended license. Yeah, that appears to be open out of Twiggs County. 2023 probation, 2023 riot in a penal institution. 2023 FTA, 2017 possession of a firearm by convicted felon. 2014 giving false name, marijuana possession. 2013 failure to appear and sell a marijuana conviction.
All right, state.
Your Honor, this incident took place July 14th of this year. Officers were dispatched to a disturbance at 1253 Easton Street. The victim in this case is Asua Johnson. She's the defendant's mother. I'm sorry if I'm mispronouncing your name. The defendant is her eldest son. She states that he kicked in her front door and then kicked a hole in the drywall to her home near her kitchen. She told police that the defendant is homeless. He's recently been released from jail. You heard pretrial say he has an extensive criminal history, Your Honor. He's got some substance abuse issues. He came over demanding entry to home. Mom doesn't want him to come in, tells him no. She refused him entry and he stayed on the front porch for a while. And then shortly after, he got upset that he wasn't allowed in, kicked in the front door, told her that she was dead, and then kicked a hole in the drywall after that. The victim actually had to grab a machete, and that's when the defendant finally left her home. We have been in touch with Miss Johnson today. She states that it's her oldest son. He's homeless. He has a serious substance abuse issue with meth. He also has some MH issues that he's not receiving treatment for. She believes that his MH issues are getting worse. She really wants him to receive some kind of treatment for MH and the drug abuse. She states that he's been in and out of jail for several times. She states that she wants contact, but she's afraid of him. And because of his mental state, she also has an 8-year-old and a 17-year-old in the house with her and who are also scared of him. Your Honor, pretrial did a great job of his criminal history. It's extensive. It's all very recent. At least 10 arrests in the last year. One of his counts from Twiggs County has 38 counts in it alone. Your Honor, I would be asking for a surety bond in this case, $2,000 on each count, no further contact with Ms. Johnson, a stay away from her home. I would also ask for an MHET in this case. I understand that MH is a serious concern here, Judge. I know that sometimes with misdemeanors, they prefer to start with a BHET. I would ask if the court could order an MHET. Of course, if the court's not inclined to do that at this point, I would at the minimum ask for a BHET. And I'd also ask for an alcohol and drug evaluation and treatment, no weapons, drugs, or alcohol out on bond. And I believe Ms. Johnson's on the Zoom, Your Honor, if you can sound for her. Thank you.
Okay. Ms. Ossawa Johnson. Do you wish to address the court today, yes or no?
Yes, I'm here.
Right, we have to see your face, turn on your camera.
You asked me not to come on camera. I'm not feeling well today, so I was still lying down.
Right, so you can't testify. I
Okay,
can't see.
I didn't have anything. I was just being present.
All right,
because
thank you. All right, PDs.
Yes, that's my case, Your Honor. We really don't have any objection to any of the recommendations of the state. We typically, because we've been more or less instructed to seek a BHET first, and then if that leads to an MHET, that appears to be what the system prefers. So that would be our only request.
Okay.
And Judge, I understand that's the typical process. I normally would request a BHET. I just think that this defendant clearly needs some services with the number of arrests that he's had in the last several years. This is clearly a situation where I feel like the mental state is declining very rapidly. And I think there's also a substance abuse issue. So it appears that most of these cases are open. So I would imagine he hasn't had to undergo anything at this point. But he keeps getting out of jail and then getting rearrested. So at some point, I believe that intervention at the bond hearing level is appropriate. Thank you.
Okay. I'm going to order the $4,000 surety bond, $2,000 on each count. I'm going to order the BHET.
Are you hot?
I'm sorry.
Okay.
You're not supposed to be speaking. Please mute yourself, Ms. Johnson. BHET. No drugs, alcohol, weapons, or guns, and no unprescribed medication while on bond. And I guess the state asked for no further contact, correct?
That's correct, Your Honor.
And a stay away?
Yes.
Okay. Both of those. And I guess that's it.
And Your Honor, for everyone's benefit, I did realize that he does have another criminal trespass case that is open with our office but has not been accused at this point. It's a bind over. Bond won't be an issue. I will make sure that that case is accused before the SAP reset date.
Okay. All right, next.
We're gonna do position number 9.
This is 24 CR 005712D. Joshua Vance, 1 count of criminal trespass, pretrial.
7 total. 2017 simple battery DB dismissed. 2013 simple battery DB conviction. 09 FTA 07 battery conviction. That's it.
Okay.
Your Honor, this is my case. I would note that the prior convictions in this gentleman's history for battery family violence in 2007 in this county, an 08 case, was against the same victim. Her name is Nekelia Bird, Nekelia. In addition, his 2013 simple battery family violence was also against the same victim. He was ordered to complete anger management classes as part of his probation in 2008 and 2009. In addition, his 15 CR case from 2013, where he hit Mrs. Bird in the face and pushed her to the ground, also included those requirements. He does have a null prost simple battery out of Clayton County from 2017 that I was not able to confirm whether it had occurred against the same victim. The case in front of you today, Your Honor, is a delayed arrest. It's from May the 11th of 2024. At about 1 p.m., police responded to a dispute at 2721 Old No, like OLDKNOW Drive, excuse me. The victim, Ms. Bird, reported that her ex, the defendant, Mr. Vance, was coming to pick up their 16-year-old child. Her child had some behavior issues. And when the defendant arrived, he yelled that she was not going to talk to his child that way. And instead of being a parent, he demanded that she open the door while screaming at her, and then he kicked in and damaged the screen door to her residence. She reported that she's currently pregnant, and she believes that may be part of the issue here. Investigator Muzan Hall with APD reviewed the report and the body cam and this defendant's history and took the warrant out. It has been active since right after this happened. He was just picked up. We have not been able to get in touch with Miss Bird today, but we'll continue to attempt to do that in order to assure she is safe. I'm not sure if the 16-year-old child they share has been legitimated and this defendant has rights to visitation and custody, or if the child is currently living with him, but we can ask defense counsel. At this point, the state, based on his 2 prior convictions for assaults on this same woman, it will be asking for a $2,000 surety bond. Absolutely no contact with Nekelia Bird. Stay away from the location at 2721 Old No Drive. And no drugs, alcohol, or weapons while on bond, Your Honor. And if you could sound for Miss Bird, just in case she's joined us.
Okay. Miss Nekelia Bird. No. All right. Go ahead.
Yes, my client is years old. He was born and raised here in Georgia. He resides with his twin sister. He does not live with a child. He pays child support $400 a month, and he has no objection to stay away and no further contact with Miss Bird. he has turned around his life. He's gainfully employed at Forklift as a service coordinator. He's been working there for 2.5 years, providing financially for those 2 children that he has. He does not have a GED, but he studied up to 11th grade, Your Honor. We would like to request for signature on bond through pretrial level 1 as he is recommended so. And we have no objection to stay away from that location either.
All right. I will order the $2,000 surety bond. I'm going to order, and I think the state requested a stay away and no further contact with Miss Bird. Now, I do see where this happened in May. This is
Yes,
made.
Your Honor. It's a delayed arrest. I'm not sure why. Warrant was active pretty quickly after that.
Okay. No unprescribed drugs, alcohol, weapons, or guns while on bond. And I guess that's it with the surety bond. Anything else that I leave out? Nope. All right, that's
I don't
it.
believe so.
Judge, can I say something? This
Who
is
are
his
you?
sister.
Who are you?
I'm his twin sister. We currently live together.
All right, were you a witness to this incident?
I was not a witness to this incident, but I was aware of the what happened surrounding it. The reason he was
Because
upset.
you have to
No,
hold
ma'am,
on.
we're going to
hold on,
object to
hold
that,
on.
Your Honor.
I'm sorry.
The state's objecting to that.
Right. You have to be a witness to the incident at this stage of the case. You can maybe talk to someone later, but you would have to know things from personal knowledge, not from hearsay or what you heard from other people.
Well, am I able to speak to his character and how he currently is? Okay. Okay. Thank you,
No,
Your Honor.
that's not my issue at the moment. My issue right now is that he will return to court. If he were to be given a bond, I looked at his criminal history, and things of that nature. So, I'm going to give him a surety bond right now to make sure we're beyond this. Since he was just arrested when 8/14, less than 24 hours ago. Anything else?
Nothing
All
further.
right. All right, next case. Can you all hold on 1 second? All right, I'm sorry. Go ahead. Who's next?
Number 6.
All right. This is 24 CR 005709E. Orlando, is it Nolly or Noli? Charged with 1 count of battery family violence.
18 total, 2022 trespass, 2011 probation. The last violent arrest I saw was in the 90s. That's it.
All right.
Judge, this incident took place August 13th. Officers were dispatched to 262 Arthur Langford Jr. Place, Unit 1307, regarding a physical dispute. The victim in this case is Vivian Henry. She advised that she and the defendant have lived together for approximately 8 years. He had returned home that morning from a family vigil from his late mother. He was standing at the top of the steps because they have a second floor apartment. And she was at the bottom of the steps and he yelled to her, "Where do you think you're going?" He starts walking down the steps as she is walking up the steps, and he pushed her and she fell down 3 steps and then fell onto the concrete. The victim sustained a gash to her right kneecap and had a bloody middle finger. Unfortunately, we have not been in touch with Miss Henry today. The state is requesting, Your Honor, I'll add that he has several, he does have 18 arrest cycles. I understand some of them are old, but he does have several prior convictions for battery and simple battery. In addition, he has several DUIs in his history. And I mention that because the victim told the police that the defendant was intoxicated when this happened. So I think that drinking is an issue for this particular individual. I'm asking if he can have a signature bond through pretrial services because his history is older, but mainly because I would like to see him have some kind of supervision for alcohol, like alcohol screens and anger awareness course. We'd ask for no further contact with Miss Henry and a stay away from their apartment, no weapons, drugs, or alcohol while out on bond. And if the court can sound for Miss Henry, thank you.
All right, Miss Henry. Miss Henry. All right, go ahead, PDs. Are you all okay with the signature bond through pretrial?
Yes, Your Honor, but Miss Henry actually was on just now. I spoke to her earlier. I saw her on earlier, Your Honor.
Okay, can you see her now? Because I can't see.
I do not see her now, but she was on for some time earlier.
Okay.
And I
Well,
also think
I'm going to award a signature bond through pretrial.
I understand, Your Honor, that the issue of them not having contact is also important. She has indicated to me that she does want to have contact with my client, that they live together, and she would like them to continue to live together. I spoke to her. It was on the Zoom. I don't know what happened. I did ask her if she had heard from the state, and she said she had not. She actually told me that she was on her way to a doctor's appointment that she had previously scheduled for some time, but that she would be coming on because she wanted the court to know that she wished to have contact.
Your Honor,
Well,
she said in the warrant,
earlier,
Judge, but I don't know what happened to her, but she was signed on earlier.
Okay.
Your Honor, I think that the warrant even states that she wanted contact with him. My issue with that at this point is that this victim is not young, and this is essentially an unprovoked attack. She was walking up the stairs and he came down and just pushed her down the stairs. It wasn't like there was an argument that happened beforehand. This was just someone who was angry and drinking and attacked her. And that's why another reason why I'm asking for these alcohol provisions and alcohol screens, because it seems like there's, given, this defendant's criminal history with the amount of DUIs that he's had and I understand they're very old, but other battery charges, that the drinking is an issue. And that's why I've asked for a signature bond. If the court's not inclined to award a signature bond with conditions for the alcohol screens and the anger awareness, then I would ask for a surety bond instead. Thank you.
Uh,
the problem I have with that is two things. As an officer of the court, our conflict counsel has spoken to the victim. That's correct, Miss
That is
McLeod?
correct, Your Honor. I spoke with the victim.
All right, and
she
so I'm
was
going to take Miss McLeod's words for the conversation with the victim, and it's true, they're elderly. We want to make sure they get help and that we don't see them down here again. And I'm going to put some conditions on them as well, but I'm toying with, the contact and sending them back into it. This just happened on the 13th or the night of the 13th, so we're still at 24 hours probably or less.
Yes, Your Honor, but the warrant also said that my client was coming from a vigil for a relative who had died. This is significant. I think this alleged incident happened at 3-something in the morning. It's a huge leap that Ms. DeCiano is making to suggest that my client is an alcoholic and all of that. My client has no significant criminal history at all for certainly the past 15 years or more. He is 57 years old. He's been in a relationship with the alleged victim for more than 8 years, and they have lived together. So to say that this just came out of the blue is not true at all, because actually the alleged victim had been texting him about coming back to the location because she was a little bit upset because he had been out for as long as he was, but he had been with some family members. In fact, I think there's one of his family members on the Zoom right now. So to suggest that he has a problem with drinking, there's no indication of that just because he had some DUIs in his past. He's had
When
no.
was the last DUI conviction?
Your Honor, I'd pull his history. I wrote one down from 2010, but there were several. I only wrote down that one. And Your Honor, I'm not trying to say, I'm not trying to make this big leap and say that this is all of a sudden an issue. In fact, I'm trying to say that this has been an ongoing issue based on his 18 arrest cycles, several of them being DUIs. He's got disorderly conduct. He's got probation violation, simple battery.
I believe the court's question was, when was his last DUI conviction?
I'm looking it up.
Pre-trial, are you still on? Do you have it any quicker?
Let's see. He's got his DUI from the latest one was in 2010. He had a probation violation for that DUI in 2011. Another probation violation for that in 2011. So two.
His last DUI was 14 years ago. His last conviction, 14 years ago.
Your Honor, I understand the defense's argument, but I think my argument has merit too, that based on his extensive criminal history that is several years old, that there at least was an issue with alcohol, and that at this point there was an emotional situation, there was drinking, presumably to cope with that, and then an attack.
Does the warrant or the police report state that there was alcohol on this occasion?
Yes.
No, Your Honor.
13? I'm sorry?
Yes, Your Honor, it does.
I did not see it in the warrant.
It's in there.
It's in the warrant or the police report?
I have not seen the police report, but I didn't see it in the warrant. And the issue is, to suggest that this man has an issue with DUI is, I think it's a stretching.
Well, I'm beyond that because that's too far back.
And he has no violent history in like 20-something years.
Yeah, I just want to know about the recent, and does it state in either, which you have the warrant, Ms. McLeod, but Does the police report state that she says he was drunk or alcohol, or he just was emotional because he had just come from a,
Okay, I'm reading the warrant, Your Honor. The defendant was drinking. He had an open can alcohol beer beverage, and he noted that he had had a couple drinks when police arrived. That's from the warrant. I also have the report. I can pull that up.
and that may have sent him back in a tailspin if he started drinking due to the memorial of the death, but maybe obviously hasn't been arrested lately for it. And I guess the reason could have been he was upset over the death. And we're all stretching there. I just want to make sure the victim is going to be safe. That's the first
I'm
issue.
really sorry that she dropped off because she certainly was on for
Well,
some.
why don't we put this to the end of the calendar and you take a moment to call her because she has not been responsive to us. And there's a concern for safety. Lots of the points you're making are valid and they'll be really exciting in front of a jury because they're factual issues. But today,
Well, I
the
guess the
safety of
biggest
this
thing
victim
is
is an issue.
if she has a doctor's appointment, maybe that's why she had to get off.
That may
Well, it would be the
well
state's position that until the court has had a chance to hear from this victim, we would ask for no contact. And if that is something that we can address later, we'll do a modification.
Your Honor, it's going to be a huge hardship for my client. He's 57 years old. They have lived together at this place for 8 years without issue. My client has no history of any kind of violence towards this person. This is his first arrest for
2 years.
Violence. It is. He has no kind of history like that. There's obviously not someone who, you don't get to 57 years old. He may have had arrests, but there's no indication that he's any kind of batterer or any such thing. And to say that he just pushed her down the stairs, that was not her version of what happened, not when we spoke.
Okay. I'm
But
going
gonna
to
try
give
to get
him
her back
a,
on.
yeah, I'm going to give him a $3,000 signature bond through pretrial. I'm going to do him at level 1. And I'm doing it through there so that he can at least take a 2-day anger awareness course. And I will not address the alcohol at this time because I don't feel like we have any conclusive information on that or that he's fallen off the wagon. So I'll just do the 2-day anger awareness, no unprescribed medication, drugs, alcohol, or weapons or guns while on bond. So he shouldn't have any alcohol while he's on bond. Can let the victim know that. I'm going to have no further violent contact with the victim.
Thank you, Your Honor.
And that's where we'll go for now and see what happens.
Thank you, Your Honor.
All right, you're welcome. Thank you.
That concludes my business before the court today. May I be excused?
Yes, I was going to say welcome back from vacation because I know you were gone. And then
I
it's like,
was.
and I apologize. I was like, what is her name? You know, if you're gone over a few days, the name escapes. And that's why I was hesitating. And I finally said, Miss McLeod. So apologize
It's
for that.
still me, Your Honor, and I'm back. Had a good time.
Okay. Very good.
Good to
All
be
right.
back.
Good.
Number 11.
Number 11. Okay. This is 24 CR 005713C, Montez Williamson, charge of 1 count of fare evasion. Pretrial.
Didn't we have him yesterday? Maybe not. 32
I
total.
don't know.
2024 paid to appear on probation out of the cab for ag battery, riot, and penal institution. Also out of the cab for 2 counts of shoplifting. Another count of shoplifting. Got an open shoplifting in the cab. Open trespass and disorderly conduct. 2019 probation. 2018 PI NOLO. 2017 shoplifting conviction. 2015, 2016 probation.
Your Honor, that's my case. This defendant pled guilty to criminal trespass at MARTA under 23 CR 002846E on August the 1st at SAP. He's back in front of the court 13 days later with a fair evasion and criminal trespass at MARTA. The incident in front of you is from yesterday, the 13th at 8:30 in the morning at the 5 Point Station at 30 Alabama Street. The defendant was seen pushing through the handicapped gate at MARTA Station without paying a fare. He has a permanent ban from MARTA that was issued to him a year ago in May 5th, 2023. Clearly, the defendant is not interested in following the orders of the court. He just pled guilty and was just in jail on August the 1st as a result of his failure to appear on that case and was offered an opportunity to plead guilty and is back at MARTA again. He does have a recent criminal conviction for riot in a penal institution and aggravated battery out of DeKalb. He's got multiple felony level convictions for shoplifting, which looks like the majority of his criminal history up to 2009 when he has a theft by receiving. That was his first conviction. I see he got first offender and that was later revoked. So theft and shoplifting remain the majority of his history. He now is a felon every time he's arrested for misdemeanor shoplifting because of his criminal history and is under sentence now on a criminal trespass at MARTA. The state would be requesting a $2,000 surety bond, Your Honor. No drugs, alcohol, or weapons. Stay away from MARTA in accordance with the May 2023 permanent ban.
All right, I guess he doesn't understand what a permanent ban means. He can't go there, but okay. Go ahead, PDs, and I'll give my ruling.
Your Honor, Mr. Williamson is 34 years old. He is currently residing with his mother and father and brother. Your Honor, he's recommended for signature on bond through pretrial level 3. He has part-time odd job like washing the car, detailing the car. So he does not make a lot of money. He makes only like $200 here and there per month. So he's qualified for public defender services, and we would like to ask for a signature on bond through pretrial number 3. No matter how many, maybe level 4 is even that, would be grateful.
No, I don't see that on the signature bond. I'm gonna order a $2,000 surety bond. With that surety bond, he has got to stay away from MARTA. Hopefully it sinks in eventually. The permanent ban is in place, so he has to get around by Ubers and rides or a bicycle. And again, stay away from all MARTA, the buses and the trains, not to ride them. No unprescribed drugs or meds, alcohol, weapons, and guns while on bond. And that'll be it.
Is that $1,000 on each charge?
Oh, I forgot it was 2. Yes.
Okay, thank you.
Mm-hmm. Next.
Number 10.
10. 24 CR 005714F. Christopher Whitaker, charged of 2 counts of disorderly conduct. Pretrial.
7 total. Got an open battery, ag assault, obstruction. It was indicted out of Cobb. 2014 possession of drug paraphernalia. 2014 probation. 2013 petty theft conviction.
What was the total cycles again? Pretrial.
7.
7. Okay. Thank
Your
you.
Honor, that's my case. This defendant has history out of Florida and Georgia. He has an open felony battery, family violence, and aggravated assault in Cobb County from May of 2022. That's indicted, and a second ag assault in Cobb County, also family violence, from October of 2023. This incident in front of you occurred at 100 Chattahoochee Circle in Roswell. It's a leasing office. This is yesterday, August the 13th. at about 4:30 in the afternoon. Police were called because the defendant, who is a resident, was upset that he had just received a 3-day notice to vacate. He came into the leasing office where victim William Davis was his target initially. He became angry. The defendant became angry and yelling when staff of the location asked him to leave. Mr. Whitaker got into the face of staff there and began yelling, and specifically told Mr. William Davis and Mr. Johnny Giraldo, Giraldo, that he wanted to fight them. I want to fight you. I need to fight somebody. Leasing consultant Zion Royal was on scene and witnessed this. He was arrested and cleared at the North Fulton Hospital before being transported to jail. It's reported that people on scene, Mr. Giraldo specifically, who's the victim in count number 2, reported that he tried to separate Mr. Whitaker from the initial victim, Mr. Davis, and that's when Mr. Whitaker began challenging him to a fight and demanding that he go outside rather than leave the premises like he'd been told. This defendant has multiple open cases for violence. We would request, there's 2 counts on this case, Your Honor, $4,000 surety bond to stay away from the location. That's 100 Chattahoochee Circle in Roswell, and have no contact with the individuals that are named here, William Davis and Johnny Giraldo, Giraldo. No drugs, alcohol, or weapons while on bond.
And you said there's an existing 4,000 surety?
No, that's what I had requested. I don't know.
I'm sorry, what you requested.
Yeah, sorry.
All right, PDs.
Yes, Mr. Whitaker, I'm going to argue for you, so please do not say anything that will incriminate you. He is 29 years old and he resides alone. Your Honor, he is currently between the job, so he has no funds to pay for any kind of bond at this point. He is looking forward to get a job at Mitsubishi dealership at Chambly. He graduated from high school. He does have a little bit of MH, but he has everything under control. He's complying. We would like to request for a signature on bond through pretrial level 2, as he is recommended. So, Your Honor, and only thing is, though, they are leasing office managers, and my client has to vacate the places. I guess he can kind of like at least let somebody else know, I guess, who is not these 2 individuals at leasing office. So he will be moving out anyway, Your Honor.
All right, I will order
Excuse me,
3,000.
I'm his mom. Could I please speak for Christopher?
No, not at this point, Mom.
Not speak for him. But he is mentally disabled.
Were you on the scene or a witness?
I've been there, and I was on the phone at the time. Yes.
Well, at this point, I'm trying to determine whether he's coming back to court and will be able to. As far as the factors
he has
that
medications that he should be taking for all of this. He's bipolar and schizophrenic. He's clinically been diagnosed.
This is being streamed and recorded. Please don't.
I'm sorry.
Give those are HIPAA violations, and I don't want
I don't know how to reach out. No one to help me. He needs these meds.
Well,
I don't know
he
how.
has an attorney. You need to talk to his attorney. But please don't talk about his medication, HIPAA, or meds, or any.
I apologize. I'm
such
sorry.
as that. That's unfair to him. And PD Kim, can you chat her, give her your information so that she may reach you?
Yes, I will. Yes, Your Honor.
And Ms. Kim, did you make a recommendation for some evaluation?
He already has medical.
Just know
I
that
think
I'll join you in any recommendation. Just reach out if you need anything from me.
Thank you.
And I think you mentioned that he already has that covered, but speak to the mom to handle that, please.
Sure.
All right. I'm going to give him a $2,000 surety bond, 1,000 on each charge. Because we do have to make sure that the victims are safe. And I hope that mom will get involved and assist him as much as she can so that there will be no more victims and the existing victims will feel safe. He is not to go back to that property, stay away from that location unless he returns with the police escort for the safety of everyone involved. So if he has to move out, he needs to take a police escort with him, or his mom can go back and get his things. And maybe he shouldn't go back. So no further contact with William Davis and Johnny Giraldo. He is to stay away from 100 Chattahoochee Circle and continue on his course of treatment for MH, as well as the prescribed medications. No unprescribed medication, drugs, alcohol, or weapons while on bond. And that's the ruling of the court for today. And thank you, ma'am, and I'm sorry we can't do more at this point. But
okay, is there something I can get from them for to have the police escort so that because I have to have this paperwork,
Right.
Thank you,
Yes,
appreciate it.
yes. PD Ken, you have her information to reach out and get her a copy of the order.
Would you please give me your phone number? I texted mine.
I don't know. Are
Okay,
you able to see the chat?
Not right now. Wait, where do I go?
Don't worry about. I don't know if do you have a problem stating your number over this proceeding?
I found the chat. Yes, I
Oh,
found
you did. Okay.
Yes, ma'am.
So PD Kim is going to send you her number, and then you can give her a call later today or in the morning.
Yes, ma'am.
All right. Thank you.
Thank you.
Next.
Position number 3 made bond. We're gonna do position number 5 and position number 11.
Let's
I'm
see.
sorry. Position 5 and 12 are waivers.
Okay, 3 made bond and 5 and 12. Okay.
Yes, ma'am.
All right, you ready for position 5? And then that would be it, correct? Okay. Position 5 is 24 CR 005661C. Vincent Moss, charged with 2 counts of battery family violence. Retrial.
Third arrest, 2015 shoplifting, and was cited in 2014 for wrongful use of marijuana. I think that was in the Army. That's it.
All right.
That's my case, Your Honor. My reading of the criminal history is that is a 2014 issue during time in the Army and resulted in an administrative separation. The incident in front of you occurred on July the 17th of this year, so this is a delayed arrest. This is also a case that could be a felony ag assault strangulation. We have not been able to make contact with the victim in this case. Her name is Kartika, Karteka, Moss, Moss, and this incident occurred at 9:30 p.m. at 2461 Antwerp Drive, Southeast. The defendant and Mrs. Moss are married and live together based on the documents we have. She made a 911 call and reported that she'd been assaulted by her husband. An initial officer took the report, and family violence investigator Gruss followed up and spoke with the victim. She reported that They argued because he, during an argument, he said he was going to go call someone and talk to them about how she was behaving, and this upset her. She slapped the phone from his hand. And at that point, he grabbed her by the neck and pinned her to the couch. She had a visible scratch on her nose as a result of being pinned to the couch and this interaction. In the documents, it reports that she's unable to scream at that point and she could not breathe, that the children that they share, two of them, intervened. And their father screamed at them and told them to go back to their rooms. She was seen to have bruising on her neck, which is another reason why this could be elevated to a felony level. The victim told police that she wanted to try to leave the location, and she had taken her keys and was walking to the vehicle with the children when the defendant ripped the keys out of her hands, causing a cut to her fingers. He then fled, taking her phone. She reported to police that this was their first incidence of violence. Based on the facts in the warrants, I think the state believes clearly supporting more than 2 counts of battery, family violence. We would request a $6,000 surety bond, Your Honor. You've got two charges of battery, family violence for causing injury to this young woman by grabbing her by her neck and causing bruising on her neck. And striking her, causing this scratch on her nose. But factually, these documents support more. We will continue to try to make contact with this young woman. But at this point, we would request no contact, to stay away from the location where she may live, if that is 2461 Antwerp Drive, or if she has moved, and no drugs, alcohol, or weapons while on bond, Your Honor.
All right. PDs?
Okay, Your Honor, they have known each other since middle school. They've been married 3 years. My client works for a catering company for an airline. He previously worked for a different catering company for an airline. So he's gainfully employed and industrious. Their children are 6 and 4 years old. Noting what his record was, gives me some hope if this is their first, if they've known each other since middle school, and if this is their first violent incident, that gives some hope there, Your Honor. So it asks for the court to consider a signature bond or a very low surety bond.
If you could sound for Ms. Moss.
Let's see, is it Kartika Moss?
Yes, Your Honor.
Kartika Moss, are you on? Nope.
Miss Lightfoot, Miss Marcia or Marsha Lightfoot is on the Zoom, and it looks like she's trying to do something, but I'm unclear. I don't know if she's related to this case. Apologize.
She's just a friend, but Kartika knows her. Like I said, they've been, everybody knows everybody in the family and friends circle. So
right. Thank you, Mr. McLean. She's
just observing. If I called her to testify, it would just be to say, does this guy show up?
No, thank you.
All right. I know that this is the third arrest, and I am alarmed by the injuries. And there were kids there as well who tried to intervene. So it sounds like the situation was a little volatile. My problem with it, though, it was July, and this is August. I don't know what's happened in between the time, whether they reconciled or something else, but I will give the $6,000, $3,000 on each, $6,000 signature bond through pretrial. I will put him at a level 2. I will order him to take 2-week anger awareness courses, 2 weeks through pretrial. I'm going to order that we have no unprescribed medication, drugs, weapons, or alcohol while on bond. I'm trying to think about this contact here. What did the state recommend?
Your Honor, based on the facts of the warrants and documentation, we would argue this is an aggravated assault, strangulation, and a false imprisonment, and there should be a cruelty to the third degree, 2 charges because there were children present. In addition, he took her phone when he left, and that's a theft by taking. We are asking for no contact, and there's a reason for that. And I would argue that if there's someone here on the Zoom who knows both of these people and is here to support the defendant, and we have a victim who hasn't responded back to us, that's because the defendant and she reconciled because he wasn't picked up in a timely manner, and she is truly a victim at this point. No one is here to speak for her.
It's because I interviewed him and asked for phone numbers and called them.
And you just reported that this person is a friend to both of them. So why not call your victim and ask her to come give her input? It's very convenient that she's not here, isn't it?
Heard you say you didn't want to hear from her.
I don't want to
No,
hear
she
from
didn't
someone who's not a
say-
witness, but you just
She didn't
did
say
say
she
that this
didn't want to
person
hear
knows
from the
both of them.
victim.
So where's the victim?
Well, if y'all make up your mind, if you want to hear from her, that's fine.
She didn't
I
say that,
don't.
Mr. Plain. She said she didn't want to hear from the friends. But you did not say that you had any contact with the victim. If you have, or we can have the victim here, we would like to speak to and hear from the victim.
No, Your Honor, I've had no contact with the victim.
Okay, that's what we had asked for. Thank you. All right, I'm going to, again, the $6,000 signature bond through pretrial, $3,000 on each. And level 2, I'm going to order him to stay away from the incident location and have no further contact with the victim until we can hear from her and make sure that she is safe and that she and the children are safe. So no further contact right now. And stay away.
Is this inmates or something?
I don't
No,
know.
it was quarantine.
Oh, I was about to ask why he's not in court. I don't
Medical-
really like people getting pretrial and we can't see them.
Oh, for the waiver?
No, I'm just saying, like, you
Yeah.
just need to lay eyes on them.
It was
But,
a
I
medical,
get it.
it was a medical thing. We were in court yesterday.
Oh, he was here yesterday?
No,
He
he
was-
couldn't be seen
Oh.
yesterday.
He was in the courtroom long enough for me to interview him, and then they said that they shouldn't have him at 2.
All right. Well, let him know I guess whenever he done, he got a report. So
All right.
I thought he was in quarantine.
That's
I don't
correct.
know. Well, he got the signature bond, so they probably gonna go and put him on the street tonight and get him out of there.
That is,
Who's next?
12 is
12.
lucky number 12. We got it. All right, 24 CR 005671H. Is that Anil Yakula?
correct.
Oh, okay. 1 count of battery, family violence, and 2 counts of cruelty to children in the third. And that offense date, what is it? August 11th. Okay. All right, pretrial.
So I guess this quarantine too. I got first arrest.
Oh,
That's my
another one.
information too.
Oh. It's on the uptick.
So
All
there are 5 charges, Your Honor: battery, family violence, and cruelty to the third as it relates to that because of the 2 children present, as well as 2 counts of simple battery, family violence.
Uh-huh.
This is an incident that occurred, one moment, I believe on the 11th.
Mm-hmm.
Yeah, this is a Alpharetta incident from August the 11th. From between 3 and 6 p.m., police were called to the location on an unknown problem. It might be because there's a language issue. They responded to 4201 Cypress Court in Alpharetta. Dispatch reported that they heard a male on the line out of breath saying something about his wife and then saying, "I'll call you back," before hanging up. When 911 tried to call back at the location, no one responded. On the scene, police officers heard yelling and screaming from inside the apartment. They heard a female voice yelling and screaming. They knocked and announced their presence and why they were there. At the door, the defendant opened the door and his wife was visible behind him. They were separated and interviewed. The defendant was seen to have a torn shirt and blood on his teeth near his lower lip. He reported that he'd had an argument with his wife. He reported that there was a language barrier and the police experienced a language barrier. But what they could understand is he wouldn't talk to them about how his lip got bloody. And when asked if there'd been prior incidences with his wife, his response was, "Not this deep." Victim was on the scene and she spoke to officers. She said that there was an argument that turned physical. The defendant put her to the ground and put his knee in her chest, and she had marks on her right knee and had pain in her chest area. They have 2 children who were in the back bedroom. The victim said that the argument that they had turned physical because of something the defendant's father said. So his parents, her in-laws, live in the same location. She reported that the defendant's shirt was torn because she was holding on to it as he was beating her on the floor of the kitchen. He pushed her up against the front door of the apartment with one hand held on her neck, and he had his other hand against the door. When she was asked if her breath had been impeded, she said no. There weren't any marks seen on her neck, but she reported that as a result of being thrown against the door and held against the door, she then fell to the ground. And that's when the defendant kneed her in the chest. This caused rug burn-like marks on her knee. And she reported that was where she was held to the ground, the marks there. She complained of chest pain and neck pain, and she was evaluated on scene by EMTs. The defendant's parents were present and witnessed the assault. There were identified as not being English speakers, but also being potentially biased. 2 children on the scene were reported to have observed the assault. One young woman, her name is S.A.I., first name. She is one of the children named in a cruelty in the 3rd degree count. She said that to the police that daddy hit mommy, and she observed the defendant strike her mother 3 times. She said that fighting happens frequently, and when asked if dad is usually the one hitting mom, she nodded her head yes. The other child, Hari, was reluctant to speak to the police, but did say she heard an argument from the bedroom, and that when these arguments happen, like they happen frequently, she and her sister are usually sent to their bedroom. Another officer on scene was sent out to specifically speak with the children and kind of build rapport with them. However, someone who was described as an auntie took the children and shooed them away and prevented this officer from communicating with them. We have been in touch with the victim in this case. We were not able to speak with her yesterday. I was able to get a copy of the victim written statement through the help of an interpreter and the complete police report today from Alpharetta. And then it looks like we were able to make contact with her today. Basically, and she's here on the Zoom, so she can explain to Your Honor, perhaps, but let me see. Let me make sure I don't misrepresent. She's asking for no violent contact. The state has some concerns about the facts of this case and the fact that children are present, that there may be a language issue. We've got a particularly vulnerable household of people, and she's there with her in-laws living with her, and her children were prevented from further speaking with police. In addition, the one child who did speak with police contradicts what the defendant's position is at this point, and frankly, what the victim has told our victim advocate, that these fights happen frequently, and it's usually daddy who hits mommy, and that she witnessed the defendant striking mom. And I don't believe mom is saying that these things did not happen this week, but it's the state's position that she may not be in the best position to judge whether or not she's safe. So we're requesting no contact, Your Honor, but of course you can speak with her. He has no history. And so we're requesting a surety bond. We'd ask for $1,000 on each count, no violent contact, and no drugs, alcohol, or weapons, Your Honor. Obviously, the contact is going to be the thing, and we'll leave that up to your discretion.
Okay. All right. And The victim is on the line. What's her name again?
I believe it is Varalakshmi, 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 last name Yakula, Yekula. Miss Yakula, you're gonna have to just hold on a second and go slowly, okay? So the judge can swear you in.
Okay.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay. All right. You can put your hand down. Do you want to have any further contact with your husband, Mr. Yakula?
Yes, I want stay. I want he come back to home. I want to stay with him, ma'am.
Okay.
Yeah.
All
He's a
right.
nice
But we
guy.
want to make sure you're going to be safe and you're not
Yes,
going to
safe.
have
We are safe. We are
any
safe.
more arguments,
No.
and that you won't be in fear of them. If you were, you would call the police again, correct?
What would call? No.
If he came
won't.
back home, and started, I guess, having violence or arguments with you, would you call the police again? Would you
Sorry,
call the
I can't
police on him?
understand. Would you call the police? No.
You wouldn't call the police on him again if he started doing something
Okay,
scary to
okay.
you again?
Okay. If he is doing something, I will call the police again. But he didn't do that again.
Well, he hasn't been home. He's been in jail, right? I'm saying if he gets out of jail and comes back home, he's still got to be calm to you, correct?
Yes, yes.
And you think that can happen?
Think that no.
You think that's possible?
No.
Do you have anyone with you to interpret?
You interrupt. No, no, ma'am. No, I can understand a little bit, but I can't explain. But he is okay. He is caring husband and responsible husband. That incident happened. That day is a bad day. I'm really sorry. Please send him back. Kids are asking. He's okay. He's okay. We are safe with him.
You have children?
Yes, children's also safe with him. They are asking
How old are your children?
One is 10 years old, another one is 6 years old.
10 and 6, okay. Okay. Any cross-examination questions by the other attorneys?
No, Your Honor. The state just has concerns about whether this victim will feel free to make contact with police if there's another incident, whether she's concerned about her husband coming home because she needs the support, whether she has any other support here in the community, and arguably she's just stuck at home with her in-laws and this gentleman who treats her like a child and punishes her corporally in front of their children. That's alarming. We'd ask for some anger management or maybe the beginning an enrollment into DVIP. That seems like it would be appropriate.
Well, I won't go as far as DVIP yet. I will order some anger management. Preety, do you have any objection to a signature bond?
No, Your Honor, we don't have any objection to that. Let me note that he is a software consultant and he will not be qualifying in the future. I advised him. I went to visit him at the jail because of the absence from court situation. And so we had a talk and I told him some resources. We would not object to a bit of anger awareness or anger management. I would think that he's free to get DVIP if he wishes to already, but as far as court orders go at this point in time, anger awareness would be probably appropriate, Your Honor.
Mm-hmm. Well, I'm glad you told me that. How old is he again?
Oh, let's see. His age, I'd have to grab the calendar to see his date of birth.
43. 43.
How old is he? 43?
Yes.
Born in 1980.
Yes.
All right, he's 43 years old and he's a software consultant, so he must make a pretty good salary. So I
Well,
guess he,
with 5 dependents, it's not that high, but it is it is a good salary, but he has a lot of dependents, Your Honor. He does have an MBA and a bachelor's.
then I would maybe change my mind about DVIP because he probably could afford it. But I'll give him a $4,000 signature bond. Trying to see, I'm going to go ahead and I know that pretrial just said they like to lay eyes on him, but I want him to report and to get some courses to hopefully make sure this family is going to be safe. So that'll be $2,000 on the battery, $1,000 on each of the cruelties for a total of $4,000 signature bond through pretrial. Wanting to take 6 weeks of anger awareness courses.
Excuse me, Your Honor, he has 5 charges.
Is it 5? I see 1, 2, 3.
Yes, it's 5.
Oh, I guess I didn't turn the page. All right, so let's make it 4. Let's make it 6,000, 1,000 on each of the simple batteries for a total of 6.
Okay.
6,000 signature bond through pretrial, 6 weeks of anger awareness courses. I'm gonna put him at a level 2. No further violent contact with the victim. So, Miss Yakula, you still on?
Yes, yes, ma'am.
So I'm going to explain this to you. I hope you understand me.
Okay.
He's under a $6,000 bond to get
Okay.
out of jail, and he has to take 6 weeks of anger awareness courses,
Okay.
and he has to report into pretrial 2 times a month. But I'm letting him come back home, but I'm ordering him to have no further violent contact with you. No screaming, no hollering, no pushing, no hitting, no touching. And if he does, you are ordered to call the police, and he will come back to the Fulton County Jail.
Okay.
And
Thank you, madam.
that goes for your children as well. He's to have no violent contact with your children either. Okay?
Okay. Yeah.
You
Thank you.
have a right. You have a right to be safe in your home. Okay.
Yes.
Okay. All right.
Thank you.
That'll be it. You're welcome. All right. Is that it?
That's it.
Okay, are we ready to go over the calendar?
Yes.
Okay, once again, the reset date for the SAP calendar is August 27th. Position number 1 is reset further notice with a total $2,000 SOB through the jail. Position 2 is going to the SAP calendar with a $1,000 good bond. 3 is reset further notice as the defendant has been released. 4 is going to the SAP calendar with a total $4,000 good bond. 5, reset further notice with a total $6,000 SOB through pretrial. 6, reset further notice with a $3,000 SOB through pretrial. 7, reset further notice with a total $2,500 SOB through pretrial. 8, reset further notice with a $2,500 SOB through pretrial. 9 is going to the SAP calendar with a $2,000 good bond. 10, SAP calendar with a total $2,000 good bond. 11, SAP calendar with a total $2,000 good bond. 12 is reset further notice with a total $6,000 SOB through pretrial. And for our add-on, it's been reset further notice with a $3,000 SOB through pretrial. Are there any questions, comments, or otherwise?
Get the amount for number 7.
Number 7's amount is $2,500 SOB through pretrial.
And what was the amount on the add-on?
The add-on amount was $3,000 SOB through pretrial.
Thank you.
You're welcome. Are there any others?
Nope, that'll do it.
Okay,
All
everyone
right.
take
You
care.
all have a good one. All
All
right.
right.
Bye.
Bye-bye.
One moment.
Yes.
It looks like maybe Miss Moss has joined us. Someone with the defendant's name for number 5.
Ah, okay. So you have her. She on? I can't see.
Her camera is not on, but she is on the Zoom.
Miss Moss, can you turn on your camera? Can you hear us, Miss Moss?
Hmm.
All right, let's go.
Okay.
Thank you.
No, I appreciate you guys. Have a great night.
You too. Bye-bye.
Good one.